All right, so I've got Brad Busbin joining us here today, going to be going through a lot more about estate planning. Do you need to be updating your legal documents? With everything going on at home right now, out in the world, you're probably sitting around going, oh my gosh, what do I need to be doing? What are the things that can occupy me other than Netflix and watching about, the Tiger King, right? So we've got Brad that's joining us. Brad's been with their firm for over 10 years. A few years back, actually decided to take the bar and wanted to help people out with estate planning. So Brad, I know that that's been a passion for you and helping people out as they go through and navigating this. So can you give us a little bit of information on that when it comes to estate planning and some documents that you need to be updating with this COVID-19?
Yeah, so there's a couple of things you want to think about. You want to think about, one, your advanced directives, which are your power of attorney, your healthcare surrogacy, and then your living will. The first question you need to ask yourself is, do I have them? And if you do, the next question is, where are they? You want to make sure these documents are readily available to you and to anyone who may need those on your behalf. Going to jump in right. One of the most important one is the durable power of attorney. The durable power of attorney is a document that allows someone to stand in your shoes and make financial decisions on your behalf. So why that's important, okay? If you're in the hospital and you need someone to make medical decisions, well, the state of Florida, the Florida statutes provide that someone actually can make those medical decisions on your behalf. But if you're in the hospital and you can't make financial decisions on your behalf, you need someone to be able to make those decisions, someone to be able to write checks on your behalf, make sure your bills are paid on your behalf. So it's important to have that durable power of attorney. Additionally, the reason you want that healthcare surrogacy is you want to assign who you want to be making those decisions. You may have family that is close by, but they may not be the family members you want making those decisions. If you have a child that maybe, or brother or sister that's a doctor, maybe you want that person making those decisions as opposed to the nearest relative to you. So you want to have that document so that you can actually say who is actually going to be making those decisions on your behalf. The last one's living will, and that's just your advanced directive as to whether or not, if it comes down to it and you're in end-stage condition, persistent vegetative state, or a terminal condition, and your doctors have determined there's no medical probability of your recovery from that condition, that you don't want to live like that. You don't want to be kept alive by artificial means for a prolonged period of time. With these documents, you also want to know, are they current? If you have them, are they current? Are they still the individuals that you want to choose with those documents? And one other thing you want to start to think about is your adult children. Okay, so if you have children over the age of 18, they need these documents. It's very important that they have them so that someone is designated to be able to make these decisions. If you have an adult child who's single, that in their 20s, has bills to be paid, well, someone needs to be able to go in and make those decisions and be able to make those payments on behalf of the children.
So what happens, Brad, if you don't take care of that, if you don't have those type of things in place? I know when my wife went in to have our first and second child, right? When you go to the hospital and you check in, you get to do some of those power of attorney things, right? Do those work the same way as this, or how would that work?
So that's correct. So you can, when you go to the hospital, you can assign someone to make those decisions for you when it comes to healthcare decisions. Now, generally, those documents you're signing at the hospital don't include the documents for financial decisions. So even though you're in the hospital and you've got someone who can make medical decisions on your behalf, who is it that's going to be making financial decisions? And without the durable power of attorney, to be able to access those bank accounts and other accounts on behalf of someone, you got to go to court to do it. You got to get a court order. You got to be appointed as a guardian. That's not something that's done in a day. So it takes a little bit of time to do that, and it takes a bit of money to be able to do that as well.
Now, heaven forbid, obviously, with all of this going on, unfortunately, we're seeing that there's a continued uh, death toll, that there's people that are passing away. So these documents, do they hold true after that person passes to be able to help make those financial decisions with dispersing, or do you need something else for that?
No, so those documents, all of those documents cease to have any power once a person passes away. So a power of attorney will not be valid after the the individual passes. So you will not be able to access bank accounts or anything. That's why it's important to have your other estate documents, will, trust, and your beneficiary designations all up and current. Um, if you don't have a will in place, then one, probate's going to have to start for an account that was an individual's name who passed. So the probate process take a while before you can actually get a personal representative appointed and be able to get that money out. Additionally, creditors are going to come into play in that situation as well, and any assets that are there could be depleted by those creditors. So it's important, one, that you have your will. You've decided, who you want to receive your stuff. People have worked hard to accumulate the wealth that they have. And it's important that they keep it. So they want to make sure that they're doing things the right way. They also want to take a look at those documents. If you do have a will, if you do have a trust, when was the last time you did it? I talk to clients that are in their 60s, and last time they did their will, their kids were minors, or I had a will, but I have 3 children, but only 1 child was actually mentioned in my will. So, it's things like that. They have the documents, but they're just outdated. They don't really hold any value, if you will, because they're so old, and they just need to be looked at and updated once again.
So how many years should somebody be looking at that and saying, wow, it's been X number of years, maybe I should review that? Do you have kind of a rule of thumb?
Rule of thumb, in my opinion, is roughly about every 3 to 4 years you want to review your estate plans. Make sure they're still in line with what you want to happen. Additionally, we've had a number of changes as far as tax law goes, and maybe something that was done previously doesn't need to be as complex as it needed to be back in the 90s. I've seen clients that have come to me with trust documents that were created back in the mid-90s. Well, the estate tax threshold was $600,000 in the mid-90s. Well, it was easy to get above a $600,000 estate could have easily happened. Now, the threshold's $11 million per person. So there's a great disparity, and the estate planning that was done to avoid estate tax at $600,000 is not necessarily needed under the current estate tax at $11 million per person. So you can have a trust that's overly complicated, trying to avoid estate tax at a threshold which is no longer relevant at this point in time. So reviewing those documents, making sure they're current and that they're as efficient as possible is another thing that's important to do.
Now, that change that happened, that was under the Trump tax code, correct? That changed with the estate planning. Does that threshold change as well at the end of 2025? Is this something that people need to be looking with their planning further out also of it? Are their legal documents going to hold up with that change expected at that time?
So that is correct. So under the current tax code, this was brought in under the Trump administration, and it was increased to its current level. It will be indexed each year. It is set to sunset in 2025, as you mentioned, and revert back to the $5 million level, inflated from that level where it was previously at. So it was previously set to sunset as well. It's unseen whether or not, but that is a date to keep in mind and to pay attention to what actually happens as far as that estate tax goes in 2025. It's something to be mindful of, and if changes need to be made, that would definitely be a time to revisit looking at your documents to make sure that they are still in good order and avoiding any estate taxes under whatever the change may be at 2025.
Okay. Now, I know this is one of the things that you and I talk about often. It's people go and maybe they've done estate planning in the past and they spend a lot of money to go get these documents created, right? They do the will, they do the trust, they set all of this up, but they forget one little thing, and that's updating beneficiaries on accounts. Why is that so important?
So it's extremely important, Andy. If you don't update the beneficiaries on your account, you have a very expensive stack of paperwork. If the money is not actually titled or pointed to the trust in any way, or what we refer to as funding the trust, then whatever you've laid out to as far as happening via that trust isn't going to happen. So you're looking at, you want assets to come in and be distributed to your beneficiary in such a way, but if no assets actually ever come into the trust, then they're just not going to be distributed that way. So it's important to make sure that you are looking at those beneficiary designations, making sure they're current, making sure they're pointing in the direction that you wanted them to. If you have a trust and you wanted assets to be distributed a certain way, then the trust needs to be listed as a beneficiary. At a minimum, a contingent beneficiary on those types of accounts. Another thing is a lot of people forget, they work with financial advisor, financial professional like yourself. You handle that for them with the accounts that they have with you. But a lot of times they forget about their work accounts. A number of people have, with their work accounts, they have life insurance, they have 401ks, they have deferred compensation plans, they have all these benefits that they get from their employers. But if they're not aligning those beneficiary designations the same way, then those are once again going to bypass. And it's important because if you don't have the appropriate beneficiary designations listed, those accounts or even that insurance may be subject to falling into probate. And that's not what you do. And the reason people do a trust is so that they can avoid probate. Probate can be long, it can be costly, it can be burdensome on the family. The last thing you want to do is forget to title an account properly with a beneficiary designation and have that account have to go through probate and be subject to the reach of any of your creditors should you have them.
Now, I know we did a video that we went through specifically on that. It was one of our Lunch and Learn series. So if that's something that you're watching this right now and you go, well, what is probate? What actually goes through it? What avoids it? You can click the link below that we're going to have if you're watching this on YouTube, so that you can go to that video and watch that presentation as well to be able to help out. You mentioned with that going over and kind of listing out your assets that you actually have. That way, with those beneficiaries. What are some of the important things to keep in mind when you're looking at assets?
So I think it's important in helping clients through both the estate planning process, but then also helping families that through the probate process where they may not have done sought the counsel to make sure everything was set up correctly. I find family members that are finding accounts just later in life, and it's one of those things that we just want to make sure that you're paying attention to. Make sure it's better to go ahead and list those, list out those assets, where they're held, and contact information for your beneficiaries so that it's easy for them to find. Okay, it's not we're not playing, we're not hunting Easter eggs here. We want to make it easy on our family to be able to find where accounts are. The last thing you want is all of a sudden you get through everything and then realize there was one account that never had a beneficiary designation, or wasn't titled to the trust, and now we have to go and do something and it's years later or something to be able to transfer that account to someone. So make sure you're listing the accounts that you have. Make sure that you're listing not only the contact information for the companies, if you have a statement or something from the account too, just having that information makes it easy for someone to go and have basically your all of the accounts that you have in one spot, know what they need to do if something happens. So.
Okay. Yeah, we've actually, because of this exact reason, as a firm, we've developed helping people out with a format that they can collect this information. So if that's something that you're worried about, that you're saying, how do I actually know what accounts I have? What are the passwords to all the online accounts that you can reach out? There's just click the link below. It takes you straight to my calendar, 15-minute phone call where we can help get that guide to you to walk through. So if that's something that you're worried about, hopefully that helps you out. It's a nice little value that we want to provide to everybody that's watching this video because we believe in it so much. So that's a fantastic way to know what's going on. Brad, if people have questions when it comes to the legal side with estate planning or maybe gaps or concerns in their plan, how can they get in touch with you?
So I can be reached two ways. You can either reach me at my office. Phone number here is 407-955-4595. Once again, that's 407-955-4595. Or they can email me at Brad, B-R-A-D, at busbinlaw, busbinlaw.com. So.
Fantastic. Thanks so much for sharing that. You know, we firmly believe that this is one of the pillars when it comes to a financial plan is the estate planning piece and making sure you're prepared. None of us know what tomorrow is going to bring, right? Nobody expected that we were going to have a mass pandemic that created this immense need when it came to legal planning, making sure your directives are met. So this is something you don't want to wait on. You want to take advantage and work with a certified professional on this, whether it's Brad or myself or anybody else. We want to make sure that you're getting good information here. So this is a time for you to be able to act with that. Again, if you have specific questions, you can click the link below for 15 minutes to have a conversation. We're happy to help you out with any of the questions that you have, whether it comes to estate planning and are your accounts set up correctly, or do you need to do something different with your financial planning? We appreciate your time, and we're glad we could share this video with you. Thanks so much for joining us, Brad.
No problem. Thanks for having me, Andy.